morning, good afternoon, or good evening, everybody. I'm Harry Barth, the founding member and senior member of the asset protection planning firm of Barth Calderon. At my side over here is Martin Greenbaum, the managing director, founding person of Martin Greenbaum law firm, and we're going to bring you today what we think is a very, very interesting program that I think that all of us should have been happy to have seen years ago, but hopefully you'll get a chance to see it now. Martin is in the business of collecting judgments and collecting revenue. He would be your prototypical, but much better than prototypical, collection attorney, and what we're going to bring to you today is an opportunity for you to see the interface on both sides of the aisle, so to speak, on what would happen in the event of a professional liability that we'll talk about in a moment. Martin, why don't you tell us a little bit about your firm and what it does?
Thanks, Harry. I'm Martin Greenbaum, Greenbaum Law Group, and our firm only engages in commercial collection and judgment enforcement, which means I and all of my lawyers are the person who comes after people who owe money or have judgments. I am the biggest enemy of the debtor. Thank
you, Martin. So let's just take a second today and chat a little bit about what happens. So there are a few things that we need to know about asset protection planning, and Martin, I'm sure, will ratify the next few things that I'm about to say. So first of all, asset protection planning, in order to be effective, appropriate, proper, and professional, needs to be done before the act or the event arises. Otherwise, Martin will be able to collect relatively easily on the liability that you have. Two, that living revocable trust, the living revocable trust that we have, provide no asset protection. People say to us all the time, is my home safe? Are my assets safe? I have them in my living revocable trust. And the answer is that if you can reach the assets, Martin and his team can reach the assets on behalf of the plaintiff. And third, that we have insurance for that. I think insurance is very, very important. It gives a place for Martin to go to collect, but it's not the know-all, end-all, but it serves a very important part in asset protection planning, because a judgment can come in excess of the insurance that we have, or we can have a judgment that's, or a legal action that's not covered by the insurance policies that we have. So just before we move into the substances of all of this, just a couple of interesting statistics. Last year, 50 million lawsuits were filed in the United States of America, and 95% of all litigation in the world occurs in the United States of America. That is absolutely amazing as we have the litigation revolution in full speed. And although there are many, many, many attorneys that are good at obtaining the judgment, Martin isn't the best at collecting that judgment. And so my job is to do the best that I can to prevent Martin from being able to collect those judgments as best as he possibly can, and hopefully achieve a settlement that makes some sense in light of the circumstances that we have. Am I saying that right, Martin?
Yes, you are, and a lot of it is not always because a judgment is entered, it's because a judgment is threatened. So even in a collection case, when I'm going after somebody, if they have asset protection, the settlement value is dramatically lowered. Good asset protection means that if I win, I probably won't get as much as I expect, so I'm anxious to settle. And if it's in place before you need it, it doesn't neutralize, but it sure dilutes all of the claims of the creditors.
Yeah, and what we're going to do is we're going to walk you around today utilizing California law, and recommend understand whatever state that you live in may be slightly different from the rules that we're showing today under California law. Now, I would like to imagine for a second, although it's somebody wouldn't like to imagine for a second, that us or you as a practicing professional have been involved in a case of professional negligence, and we may have some significant liability. I'm not going to take the valuable time of you visiting us today to hear us to talk about all the various different ways that can happen to accountants, to lawyers, to doctors, to architects, to engineers. But we do need to understand, very important part, that for the vast majority of professionals, our entities, our LLPs, our LPs, our Incs, do not provide protection for us for the personal liabilities that have occurred, because we are always personally liable as practicing professionals. So what I'd like to do is we're going to turn around and we'll use Jane Doe and John Doe, and we're going to take a look at their net worth under California law, and we're going to talk about what would happen in the event that a multi-million-dollar judgment is visited upon John Doe, a practicing attorney and or CPA, or a combination of the two. So in looking here at the board, we're going to have a collection of assets. So Martin, what we'll have here is we'll have a 401k, we'll have a rollover IRA that came from an ERISA plan, and we'll have a traditional IRA, another one that we do the 2,000, 4,000. We'll also have John and Jane Doe in a California, a community property state. They have a home, stocks, bonds, and cash. They'll have a California college-bound 529 plan. They will have in life insurance cash values, not face amount now, cash values, $80,000 worth of cash values. John will have inherited a cabin from his parents up in Lake Tahoe. They'll have a rental property, which was their old house, that's worth $400,000 with a $100,000 mortgage on it. And then they have some businesses. So we'll talk about the businesses that they own. So we have, besides being an accountant and or an attorney, they also have some operating businesses. An S corporation in California. The other one is a Delaware C corporation, authorized to do business in California. One is a California single-member limited liability company, and the other business is a multi-member Nevada and or Delaware or South Dakota or Wyoming LLC. All right, Martin, so let's take a look at this. So poor John, he made a mistake. He was involved in a securities offering, and now he's being sued, and probably most likely will have a judgment in multi-million dollars, maybe in the terms of maybe $5 million. And he carries $1 million worth of insurance. About 200,000 of it's already been used up on his defense. So he's got about $800,000 left under the contract, and so therefore there's approximately a $4.2 million judgment that most likely will be entered against John that he doesn't have coverage for. So,
and I'm anxious to get that.
Yeah, and you are. So we now know all of John and Jane's assets. So Martin, assuming that John has done nothing, let's walk around a little bit and let's take a look and see about the house. So his house is worth $1.6 million with a $400,000 mortgage, about $1.2 million worth of equity. So people tell me under California law when I go and speak around the country that that's a safe asset because there's a homestead exemption.
Yeah, but the homestead exemption, Harry, is only between $75,000. He's a married man, so now it's $100 to $175, depending on his age, his physical ability, his cognitive ability, and whether or not there's any impairment. So at most $175,000.
Really? Whoa, that's so. People, so, wow. So, Marty, I heard that people don't take away homes. Do we have sympathy for them? They're going to lose their home. Is John going to lose his home? Martin, how could that's where they raise their children. What is that all about?
And I work for the creditor. I don't work for John. I don't have sympathy for him. I have sympathy for my client, who's a creditor, who's owed the money. And so, yes, we proceed with levies on real property, and especially residential real property. They're not as easy as commercial property, but we can get the equity in your house above the homestead exemption. So 400 against 1.6, there's a big slice of equity, and I can get it.
Wow, that's interesting. Now, so let me ask you a question, Martin. Had that home, had Jane and John Doe entered into an appropriate and proper post-marital agreement after they were married and opted out of the community property system, And John was the only one that had the liability under the securities professional liability action. And the home was owned 50-50 as tenants in common between husband and wife because there's no community property. I would imagine that your scenario is going to look a little different now.
It's going to look a lot different because I can't take Jane's half, I can only take John's half. And what would I get? The right to live in the house with Jane? No one's going to kick John out of the house. And so at very most, I'd have only a claim against a half with the loan, with the homestead, and I'd have only the ability to sit there for the rest of their life with potentially a small lien on it. It's very unattractive to a judgment creditor.
Oh, that's absolutely amazing. And in that light, although we don't have time or the details today, there are other types of opportunities to protect your home, such as a residential shield trust, which is a land trust with the assignment of a beneficial interest to a limited liability company. There are some estate planning tools to help the house, a sale to an intention defective grant to a trust, and perhaps even the utilization of a qualified personal residence trust, all of which, if done properly and professionally and beforehand, will turn around and help protect the home from the claims of creditors and allow a much better settlement.
But the garden variety trust doesn't protect you when it's revocable.
That is 100% correct, Martin, and that's the way most of them are. So let's go take a trip, if we would, over for a moment to the piece of rental property that they own. It's in their living revocable trust. It's a $400,000 property with a $100,000 mortgage on it, $300,000 of equity. Are they going to keep that property, or are they going to lose that property?
They're going to lose that property within months. That property is going away within months.
So let's make a change for a second. So just a simple scenario. What if that property was held in an appropriately designed limited liability company, and again established long before the event has taken place, and so now we have the liability to John Doe, assuming that they don't have a post-nuptial agreement in effect, are you still going to be able to reach inside and take that rental property away from them?
The owner of that house is the LLC, the limited liability company. That's not a judgment debtor or creditor. I can't take it away from them. All I can take is a charging order against their interest. It makes it much, much harder.
Right, so you'd be able to get all of the rental income should they distribute it.
Right.
Can you force them even to distribute the income?
Can't force them to distribute the income.
Interesting component. One takeaway from Martin and Harry is that one should never be in the business of rental real property or commercial property without the utilization of an appropriate and proper limited liability company. Just as an aside, because Martin has seen these as well, if the liability had risen up from that rental property, all right, a landlord-tenant probability, and now what happened is, and it's in their living revocable trust, and one of the tenants is severely injured as a result of a landlord problem, and they sue the landlord. If that landlord is the living revocable trust, then I believe, Martin, you'd be able to collect against everything that they have as well.
All of it falls in, but if it's only the LLC is going to be liable.
So that's really interesting. So let me ask you a question. People ask me all the time whether or not they can put 3 or 4 or 5 properties inside a single LLC. And the answer is, of course, you can put as many properties as you like inside an LLC. Now, the question that goes at hand for Martin and myself is whether or not that's a great idea. Looking down from the outside, so if we have a liability to the owner of the LLC, Martin's going to be limited to a charging order, which is a lien on the distributions. On the other hand, if I have a liability at property number 1, all right, and I get a judgment against the LLC that has 4 other properties, what's going to happen, Martin?
I'm going to take the other properties. Why would anybody put multiple properties into one LLC where there's all potential liability?
So, in other words, they've built for you a ready-made source of all the equity of their real estate.
They build me an account so that I can dip into it with all the good things that are coming out.
I think people should take a look at that and make sure that they don't commit that particular type of error. So now, Martin, let's go take a look over here, if we would, let's go over to the cabin, that $1.6 million cabin that John had inherited from his parents. So, Martin, are you going to be able to grab that cabin in order to satisfy this claim?
This is gold. He not only inherited it, it's his separate property.
Oh boy.
And it's his separate property, and Jane doesn't have any interest in it because it's inherited. I love the cabin. It's coming all to me, and I don't have to worry about Jane's share.
Wow, wow. So, what would it have been different if before John's parents died, they had taken that cabin, which they were going to leave to John, and put it into an irrevocable trust, which is now an irrevocable trust, for the benefit of John? Would you have been able to reach that cabin?
Almost never.
Yeah.
Almost never, unless he screws up and commingles his property. But properly administered, if it was in an irrevocable trust, I can't get it.
Wow, that is amazing. So again, we should take a look on how we inherit assets and how we leave assets to the next generation to make sure that we give them the best fighting chance against the things that risks that life may bring in their direction.
The grandchildren like that.
Absolutely. So let's take a moment and talk about our retirement funds a little bit. So we have 401k with $400,000 in it, $1.5 million in a rollover IRA that came from an ERISA plan, and $150,000 in a traditional IRA. So Martin, tell us the story here. So if this 401k is an ERISA qualified plan, meaning that it has at least one other participating employee, can you get anything?
Cannot touch that.
Can't touch it.
O.J. Simpson still gets his pension from the NFL. You can't touch an ERISA qualified plan.
But a lot of people don't recognize the difference between an ERISA plan that is qualified for protection and an ERISA plan that is not qualified for protection. So there is another thing, that's if whether or not you may have an ERISA plan, but if there's not at least one participating employee, kind of colloquially known as a solo 401k or a solo K, where it's just the doctor, just the lawyer, just the accountant, just the architect, is the only one participating in the plan, we no longer look to federal law, we look to state law. And the state law in California tells Martin that if it's not reasonable and necessary for the creditor, you can reach those assets.
I can attempt to reach those assets to the extent that they're not reasonably and necessary for the support of the debtor in his retirement years.
That is absolutely amazing. We need to take a look at that because there's an interesting characteristic that's associated with that as well. So Martin, if there's $400,000 in that 401k and you were able to reach it, do you get the full $400,000 for your client, or do you get it after taxes and after penalties?
Only after taxes and after penalties.
Yeah, okay. After taxes and penalties have been paid by the client, so you will actually get the full $400,000. So, and the client, our client, you know, John over there,
yeah,
he's going to pay that $100,000 worth of tax and the $40,000 worth of penalty.
So his $400,000 is diluted a little, quite a bit. It's diluted quite a bit.
Well, it's diluted quite a bit. No, he'll get the full. You will get the full $400,000.
But the debtor pays the taxes.
You got it. That's absolutely amazing.
The debtor pays the taxes.
Yes, that's a really bad situation. It'd be the same thing down here with the traditional IRA. So California law will tell Martin, hey, whatever not reasonable and necessary, and the court kind of looks at that almost at a subsistence level. So when Martin comes and says, hey, look, they just kept all of these other assets, they're not living on this IRA right now, I should get that. The court most likely will say, Martin, you get $150,000 that's in that IRA, and then our client, John's got to figure out how to pay the tax and the penalty.
He does.
So that brings us to an interesting one. There's a rollover IRA. So a rollover IRA is not itself an ERISA qualified plan, but the money came from an ERISA qualified plan. So I believe that that's still going to be safe. You agree?
Depending on how long you keep it there and how you treat it.
Mm-hmm.
If you commingle it or you treat it as your own, it is subject to an attack that you are no longer relying on an ERISA qualified plan.
So in other words, what's happening here is a very interesting comment that Martin just made, and that is, yes, if this came from an ERISA qualified plan as a rollover, and it's $1.5 million, that $1.5 million is safe. But people, by their very nature, may not utilize that $1.5 million properly. They may engage in a disqualified transaction, may engage in a prohibited transaction. They may turn around and do things with that $1.5 million that they shouldn't have done. And don't think for one second that Martin, as good as he is not going to look at the examination of how that rollover IRA is used. If that IRA rollover has engaged in any prohibited transaction that's going to open the door, you're going to get $1.5 million.
A great many of the opportunities I get in collecting judgments are because people commingled or did not respect their own asset protection. They had it in place correctly, but they didn't administer it correctly. They screwed up.
Wow. So there's two sides then. It's not only engaging in asset protection planning, it's maintaining the integrity of the structure.
That's right.
That's very, very important. And we'll see that a little bit when we get down and talk about the businesses. So let's go we talked about the TAHOE cabin, we've talked about the others. So Martin, what about the $1 million that John and Jane had in stocks, bonds, and cash? How long does it take you to get those?
Gone in a day.
Gone in a day.
Gone in a day. The sheriff comes into your brokerage houses, freezes it up, and within a month it's in my account.
Wow.
It's gone in a day if it's just sitting in the debtor's name.
So one of the things we need to do as far as asset protection planning, again, preemptory, long before the event, is take a look at the options that we have to protect stocks, bonds, and cash. To the utilization perhaps of a capital holdings limited liability company and perhaps held within an asset protection trust. More on that at another time, but as far as we can go in today's conversation. So now we have over here a 529 plan, which is a plan that has been put together for the education of children and or grandchildren. And a 529 plan serves a very special space under asset protection law. So I'm going to run through the protection space, and then Martin can comment on that. So under a 529 plan, there's two sets of rules that we play by. One are the federal rules. So the federal rules basically say that all the money that's not fraudulently contributed to a 529 plan, that is in a 529 plan, Martin, for greater than 2 years, is exempt from the claims of creditors. When we're under 2 years, we look to state law. And when we look to state law, we look to the state law where the plan lives and not where we live, because many people who live in California will have a plan in Virginia or in Nevada or in Colorado or in Florida, and we look to what state law says. But federal law says that in the first year, the money that's put in the 529 the first year, Martin, it's yours. Okay, take it for the plaintiff. Money that's in a 529 plan from months 12 to 24, that's the second year, $5,000 per beneficiary is exempt from the claims of creditors. So if we have $45,000 in our 529 plan, it's been there, it's in the second year. We have one child, that's $5,000 is exempt, and Martin, $40,000 is, and believe me, they're going to look at the 529 plan, how long it's been, and when the money has been contributed to the 529 plan.
And so, Harry, if the debtor is facing a potential liability, they wouldn't want to put more money into their 529 plan anyway. They would hold back for those last few years to keep it away from me.
Correct. And a lot of people will turn around and, in the period of desperation, once the liability or the professional liability emerges and runs, is they particularly say, well, let me load up the 529 plan, let me make more contributions to various different LLCs, let me set up trusts. But what Martin and I are trying to bring through to you very, very carefully, very, very effectively, that after the event planning is not going to cut it whatsoever.
Too little, too late. If you've got the liability, it's too late to duck it.
Okay, so Martin, let's go take a look over here at gold. So the people went and they bought some gold, all right? And they went to William Devane, Roslyn Capital at night. He's put on his brown leather jacket. They bought $100,000 worth of gold. They put it in a box and shoved it under the bed. So once there is a judgment, or even then they become a judgment creditor, So are they entitled, there's a legal procedure, right? Isn't it judgment debtors examination?
There is a judgment debtor's
Tell us about that, because a lot of people are not quite familiar with what's going to happen. What are you going to be asking for, and how are you going to find it?
I get a court order from a judge that you're required, the judgment debtor is required to come to court and testify under oath as to all of his property that he owns, all of his businesses, all of his accounts, everything that was subject to. I can even get an order that his wife, friends, and accountants who are holding his money or property come to court and testify as to where it is. I discover that there's gold or other collectibles or various other forms of personal property in the possession of a judgment debtor, and I get an order that either you turn it over or the sheriff breaks into your house and takes it away from you.
Wow, amazing. We don't want Martin breaking into our house, do we? Okay.
Well, the sheriff.
The sheriff, on behalf
I'm
of
standing
Martin.
next to him, that's right.
Okay, so let's take a look over here on our specialty assets, one more before we get into the businesses, Martin. And let's just talk a little bit about the cash values of a life insurance policy. Now, the cash values of a life insurance policy are subject to state law. Let me give you California's law on cash values of a life insurance policy. And then let me give you a crazy aspect of California law that you need to know that before we meet Martin. So if we have 100,000, 150,000 of cash values in our life insurance policy, in most states or many states, cash values in a policy payable to named beneficiary exempt assets from the claims of creditors. California does not abide by that. They say that $12,000 per person. So if I have $100,000 of cash values in my life insurance policy, only $12,000 of that, Martin, is exempt from the claims of creditors. Everything above that?
Subject to levy. I get a court order ordering you to draw down your cash value and give it to us.
All right, so now let me ask you a question. So, life insurance. So let's say we change the scenario just a little bit, that long before the event arose, the life insurance was purchased through the utilization of an irrevocable life insurance trust. So the owner of the life insurance is the irrevocable life insurance trust. Martin, is everything above 12,000 is safe,
Gone
isn't it?
to me. Gone to me.
There we go again. So a little bit of planning. So in the old days, we would only think of the utilization of an irrevocable life insurance trust for the basis of making sure that the life insurance was not subject to federal estate tax. But what we failed to understand is that an irrevocable life insurance trust can also be used to protect the cash values. I want to add one other factor that Martin clearly understands about, and that is in the event that he gets a judgment and the amount of against someone who is deceased, all right, as part of the estate, and the majority of the estate is made up with life insurance proceeds that happened as a result of his death. So, for example, he was driving down the road, he was drinking, whatever it may be, he veered off the road, went up onto the sidewalk, and severely injured or killed 6 innocent pedestrians. And now that estate is being sued, and not only the estate, but the spouse, it's a community liability, for millions of dollars. And they've just received a $5 million life insurance policy. In every state, just about, that $5 million is an exempt asset from the claims of creditors. But as Martin will share with you in a moment, in California, that $5 million is subject to the same reasonable and necessary test that the traditional IRA plans or traditional retirement plans are. So Martin, I would imagine, you have sympathy for the spouse and the children, or are we going to get that life insurance as needed? What would happen?
The probate court is going to make the decision. The probate court is going to decide whether I should have sympathy for my client or them, but I'm going to get them almost every time.
I agree. Same question now. If those life insurance proceeds were put into a life insurance trust rather than paid directly?
Gone to me. An irrevocable life insurance trust protects your proceeds.
As long as it's established in advance and properly and not after the fact. Okay, so that brings us down to a very important component for all of us, and that is the businesses. So let's take a look at business number one. Business number one, let's say, manufactures pianos, all right? and it's a California S corporation, all right? And you happen to own that as a side business, and John, we have a professional liability against you, and people will say to me, well, that's a separate asset, you know, has its own tax ID number, that's a corporation, that's why I set it up. So Martin, are they going to be able to keep that company, or are you going to get that company?
John is going to come to court and he's going to tell me, I've got all my assets in my corporation, I've got all my trucks, I've got all my cash, I've got all my receivables in my corporation. And I'm going to say, Judge, order him to give me the stock in his corporation. It represents all the assets. I will be soon the owner of his corporation.
That is correct, and I think that that's very important, and that's what we call an outside-in liability. And more businesses are lost to outside-in liabilities than inside-out liabilities at any one time. So I think it's very important to understand that this corporation was lost to Martin and the plaintiff, and they will liquidate it, sell it to a competitor, do whatever they have to do to reach those assets. This liability did not rise up as a result of the operations of the corporation. This liability rose up to the owners of the corporation. So let's just take that one step further, Martin. This is a Delaware C corporation, and am I going to keep that or lose that?
You're probably going to lose that, and it's probably going to go away. I might have to go to Delaware to get it, but you're probably going to lose it.
Probably won't even have to go to Delaware. It's a corporation. It doesn't matter whether it's in Wisconsin or Delaware or New York.
Now that you say it, yes, I get a California judge to tell me to give me the stock in your Delaware corporation.
Oh,
it's coming over here. And the judges, maybe they'll give me a hard time, but it'll only take a month for me to straighten it out.
Wow, so that means we have lost, these two businesses are gone. Uh-oh, let's see if we're going to do any better. So now we have a California single-member limited liability company. And so just we all know that a limited liability company is not a corporation. It's treated differently. But we also have to know that a multi-member limited liability company is treated different in many states than a single-member limited liability company. So Martin, here's the scenario. So will you be able to reach inside this single-member LLC, liquidate it, and get its assets?
Takes a little while, but I can do it.
Yes, you can. As a matter of fact, just for any of you people who want to look things up, you can look up In Re Albright, a Colorado case from a number of years ago in a federal bankruptcy court, and they can have a complete discussion of why single-member LLCs don't necessarily offer the level of asset protection. We all think of it in terms of the liability rising up from the operations of the business of the single-member LLC, but
if it's a single member,
but it almost doesn't matter. But if it's looking down, if there's a single member, there's a whole history behind that. For all intents and purposes, I believe that Martin will be able to reach inside, liquidate that single-member LLC, and call it a day.
I will, but it's a different subject with a multi-member LLC.
Right. So if we had a multi-member limited liability company established in a state that has very strong asset protection rules for their LLCs, well, Martin, would you be able to reach inside and liquidate that company?
No, I can't. I can only go after a charging order and get your distributions from that company.
Can you force me to make a distribution?
I can't force you to make a distribution.
Can you reach inside and touch any of the assets?
I can't reach inside and touch the assets. All I can do is get whatever is due or owing to you.
Okay, so here's a question for you, Martin. So, Martin, again, over here, if Mr. Smarty Pants decides he's not going to take distributions anymore and take increased salaries, so you're limited to 25%, what are you going to do?
You mean he made a fraudulent conveyance? You mean what he decided to do is rename the money so that it would be fraudulently outside of my things? Can't do that. I'm going to show that it's a fraudulent conveyance and get that money.
Wow. So I understand that. So inherently, here's something that could be done. Where all of us are talking about, so simply speaking, on that single member LLC, Martin, what if someone had just added another member?
Yeah, where's Jane in the mix here? If Jane
they added another member, then Martin would not have been able to liquidate that.
I would not have been able to liquidate.
And before the liability arose, had these entities here, the S Corporation and the C Corporation, been converted through what we call a Plan F reorganization to an LLC taxed as an S corporation or a C corporation, Martin would also have been limited to a charging order or a lien over distributions and not been able to liquidate the business.
Business would remain intact.
Correct. So I think that, you know, we're getting the picture. The picture is that with proper and appropriate preemptive planning, we have great opportunities to preserve as much of our assets as possible. Now, it's not for the purpose of attempting to screw creditors. I want to make that really clear. What it is so we can work with someone similar to Martin and achieve a qualified, best settlement for a lousy situation that we found ourselves in, and we've been more likely to achieve that if we've done some appropriate and proper preemptive asset protection planning and run everything possible. I think it's important for all of you to understand that when I speak about the plaintiffs and the creditors, what we're speaking about is where someday you may meet or need to meet someone similar to Martin, who is trying to collect for you, and I can assure you he's the best in the business. And he's sympathetic for his clients, but not sympathetic for you. So as a result, I think it's very important that for those of us looking to collect money, Martin Greenbaum and his firm is one of the best firms in the country in order to do that. When it comes time to preventing you from having to truck over all your assets, I believe that our firm is one of the best firms for you to meet with. And through a collaboration between the two of us, we can make sure that if you're owed money, that it can be collected, and if the people are trying to collect from you, that we have you protected as much as possible.
I agree, Harry, and I want to point out that anything that I've seen that you've done has been superb, but those people who try to buy their cheap trusts out of the newspaper rollover aren't going to be protected.
Well, I look forward to talking to you about this further, Martin, and we look forward to visiting with each and every one of you. Thank you all very, very much.